There seem to be questions abounding anymore about whether the government can, as part of its effort to enforce social distancing, right, and stop the spread of coronavirus, COVID-19, whether the government can stop religious congregations from assembling. There was now a quickly becoming famous exchange between Tucker Carlson and the governor of New Jersey, in which Tucker Carlson asked the governor what gave him the authority to nullify the Bill of Rights, as he put it. Now, without getting into the details, the governor of New Jersey gave a very bad answer to that question, but the question was almost as bad as the answer. One of the overriding principles I want to leave you with here is the longstanding notion among federal courts, right, including the Supreme Court, that constitutional rights are not absolutes, right? The Constitution is not to be interpreted in such a way as to lead to absurd results. It is to be interpreted reasonably, right? That's a word that flies around in the law all the time. Let's take an example, right? The Second Amendment gives people the right to bear arms, right? In several Supreme Court cases, the court affirmed that right, reaffirmed that right, held that it was an individual right, but even Justice Scalia said, right, that right comes, with limits. Like all constitutional rights, they have to be interpreted, right, reasonably. So, should somebody with a mental illness be allowed to possess an M1 tank? What if you put an M1 tank in the driveway? Do you think there'd be some questions about that, maybe legally? How about when your little one shows up at the second grade show and tell with a Tomahawk missile? You suppose maybe there may be some questions about that? There probably will be, right, about the legality of that, despite the fact that we have a Second Amendment. Now, to take the issue of religion. Religion as well, right, is, yes, there are 2 religion clauses in the Constitution. Actually, there are 3. One says no religious test for holding public office, one says no establishment, and one says the government can't mess around with free exercise. The one that's at issue here is the free exercise clause, right? The allegation is that by stopping people from congregating and praying and participating in religious services, that the government, not that it's establishing religion, right, but that it is interfering with religious practices, and that is a free exercise problem. Now, supposing that I were to develop, and play along with this, a sincere belief, right? So not making it up, really honestly, play along here. I believe, right, and I'm sane, I have my faculties, and I have considered certain belief systems, and I've come to the conclusion that as a matter of sincerely held religious belief, that I must reach a velocity of 90 miles an hour in order to commune with the Almighty, right? And short of 90 miles an hour, I can't do it. Let's envision for a minute how this is going to go over, right, when there's a police officer standing outside my driver's side window, right, asking for my driver's license. And with a wave of the hand, I say, no, I'm sorry, get away from me. You don't understand, right? My religion requires me to go 90 miles an hour in order to commune with the Almighty, right? I think I'm going to get the ticket, and things might go even worse than that. Supposing that I have a flock, okay, that I'm a pastor or a preacher of some kind, and that I have a large congregation. And then I tell the congregation at the end of one of our services, okay, here's what we're going to do. We're going to leave right now. Every one of you, with your kids in tow, get into your car right now, and I want you to accelerate to 90 miles an hour and go 90 miles an hour all the way home, communing with the Almighty as you do it. Okay, despite the fact that free exercise is built into the Constitution, right? Everybody who gets ticketed or arrested driving, right, 90 miles an hour, right, on the way home, that arrest is going to stand, right? And despite the fact that I have a right to freedom of speech, I might very well be arrested for incitement, right, to cause lawless activity. Despite the fact that, again, freedom of speech is written in the Constitution. So again, we see, right, that when you take the exercise of constitutional rights to an extreme, and when you take them to an extreme where the harm, right, attendant to the exercise of that constitutional right outweighs the right itself, right, the gravity of the right itself, courts tend to say that, okay, the constitutional right has to yield in some circumstances. Now, as to the free exercise issue, the first question that has to be asked, and again, I'm doing these videos so that people who are interested can have intelligent conversation with people who don't know what they're talking about. Right. Now, when it comes to the free exercise issue, the first question the court's going to have is whether, right, when there's a claim that the government's interfering with free exercise, is whether the free exercise clause is in play to begin with. There's a long line of cases in federal courts holding that generally applicable law does not raise a free exercise claim at all. And a generally applicable law is one that applies the same way to everybody. Right, there are no exceptions. It doesn't look like the purpose of the law was to target anybody's religious beliefs. There's no evidence that the law is being used to target people's religious beliefs. Right. So a speed limit would be like that, right? Everybody on the road has to go at 70 miles an hour or less is a generally applicable law. There's no exceptions. It doesn't look like it's meant to target religion. Now, this is why actually executive orders or ordinances or whatever the case may be that have religious exemptions built into them actually cause more of a constitutional problem than, so let me give you an example. If an ordinance just said, nobody's allowed to gather, right, and with more than 10 people, and everybody who gathers has to stay 6 feet apart, and that says nothing about religion at all, that would be a generally applicable law, right? It's a law that just applies to everybody the same way. When governors and legislatures and city councils and mayors start building in exceptions for religious services, now you're actually causing a free exercise problem because, and again, think about this. The government's supposed to be neutral, right, as to religion, right? Whether not supposed to be promoting or targeting non-religion, religion, certain religions. So if I start building in certain exemptions for certain types of religious services, then I open up a whole slew of issues about why are atheists not allowed to get together and discuss religion, right, in the same way that religious people are. Other spiritual types of endeavors where people get together, right? Do those have to be allowed? Why are those not honored, right? Like traditional religious services are. So, actually, if I was advising a governor or mayor or anybody else on how to do this, I would say don't build in any exemptions. You're just asking for trouble. Nonetheless, some of those do exist. Now, so that's the first question. Okay, does the free exercise clause even apply? Because again, if the law is just generally applicable and applies the same way to everybody, probably not a free exercise problem. You got to find some other issue. Let's say, for argument's sake, that a court were to conclude that there are too many exemptions, right? The government's going back and forth about whether to allow religious, gatherings and what kind of religious gatherings. Even if a court were to say, okay, the free exercise clause is in play here, and this whatever order it is, does burden free exercise. Here's another general underlying principle that people need to understand when they discuss this. When a court finds that the government has a burden to fundamental constitutional right, free exercise or any other, it tends to apply strict scrutiny. I'm oversimplifying here, but tends to apply a test called strict scrutiny. Strict scrutiny is a means-ends test, and let me illustrate what I mean by a means-ends test. Most of us apply means-ends tests in our daily lives, sometimes without knowing it. I don't have kids, but I can illustrate this in my own life. I came upon this scene, illustrated right here, happened to get a live shot of it. Asked my dog Lainey, who's laying, you might have heard her panting before, she's lying here right now. I asked my dog Lainey, what do you think you're doing? And Lainey said, I was just trying to clean your plate. Right, here we go, again, another means-ends test, right? And I say, well, if you were trying to clean my plate, first of all, you left a piece there. And second of all, if you're trying to clean my plate, why is there dog snot on my plate now, right? So in other words, it's the same idea, right? I'm telling you the means don't match up with the ends, and therefore I think something untoward is going on here, and I'm going to punish, right, you. So that's what courts do to the government when they find that the government is substantially interfering with the exercise of some fundamental right. Let's apply that to these bans, right, to these stay-at-home orders and to these bans on public gatherings. The interest, well, okay. The way strict scrutiny works, now we're going to get a little fancier with this, right? Under strict scrutiny, the burden is on the government, the state, the city, whatever the case may be, to show that it has a compelling interest, compelling, right? Compelling meaning very, 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 very important. I always tell students, if you're in court and a judge is asking you for a compelling interest and you're struggling, struggling to come up with one, just blurt out, save the children, it works every time, right? There is no more compelling interest than that. Well, So when we talk about compelling interest, we're talking about saving people's lives, right? Health and safety. Does it sound familiar? Right? Sound relevant? We're talking about health and safety under today's circumstances. You know, certainly a court's going to say that protecting the lives, right, of elderly people in nursing homes and the vulnerable, right, and the young people who are dying too, everybody. That in light of the existence of a pandemic, and unless you're a conspiracy theorist, I think we can all agree at this point that's what we have, right, and a deadly one, that the government has a compelling interest, right, in play. So you can see why this means ends test called strict scrutiny is strict, right? It's not just that the government needs an interest, right? It needs a compelling interest. And saving life typically is the most compelling interest. The second part of strict scrutiny, because it's a means ends test, the court would look at whether the means chosen by the government are quote unquote narrowly tailored to achieving the interest. So there has to be a close match. Narrowly tailored means the least restrictive, right, and best way possible, right? The least burdensome on somebody's rights. So if I can think, if I'm a judge applying strict scrutiny, and I can think of one better way to achieve the interest of saving life that's less burdensome on somebody's constitutional rights, then I would strike down the government's policy or law or whatever it is. That's how strict scrutiny works. So we already said we have a compelling interest, that's pretty obvious. Now the question is, are the means narrowly tailored? Well, if I'm a judge, here's what I do. I call a bunch of witnesses to the stand. I call a bunch of MDs and PhDs to the stand, and I ask them, what's the best possible way to stop the spread of this disease? What's the best possible way to protect people's lives, right? And I'm going to have person after person come up here and tell me what, in all likelihood, the best possible way to stop it is social distancing, keep people away from each other, and stop large gatherings, okay? If I have enough of those people, if I'm a judge, I'm playing judge here, at some point I'm going to turn around, right, to my diploma, and I'm going to ask the litigants to please look at the word before doctor on my diploma, right? The word before doctor on my diploma is juris, not medical, okay? I'm not a medical doctor. You don't see medical doctor on that diploma, and you don't see a PhD on that diploma, right? So when I'm evaluating whether the means are narrowly tailored, right, are the best possible way to achieve the interest, obviously judges are going to defer to experts on that in most cases. So if the government can either demonstrate that it's a generally applicable law that applies the same way to everybody, it doesn't even raise a free exercise question, or if it does raise a free exercise question, right, if the government can show to a court that that stopping people from congregating, right, and gathering is the best possible way to achieve a compelling interest, then the government would get by this test called strict scrutiny, right, and its policy would survive. So I hope this helps people discuss this, right, and particularly people who understand these principles discuss it with people who don't. The big two, right, from this video, number one is that constitutional rights have never been interpreted as being an absolute, so you're not nullifying the Bill of Rights, right, when you do something that might burden somebody's exercise, right, of a fundamental right. That's number one. Number two, strict scrutiny is the test that applies. There are no, and that's in line with the no absolutes, right? Strict scrutiny is a tough test for the government to pass, but if the government has a compelling interest and it's doing what it's doing in the narrowest way possible, it can get by strict scrutiny. No absolutes and strict scrutiny applies. Those are the two big things to keep in mind when you hear people discussing this. Hope that helps. I'll put out some other videos on other topics, and thanks for watching.